Good morning, everyone. Welcome. Really appreciate your time. It's a huge pleasure for me to introduce Chamonie. Chamonie Buys is a director at TMJ Attorneys, and she's an expert dealing with the administration of trusts and executors and the appointment of executors. So just I want to say a quick good morning, Chamonie.
Morning, Benny. Thank you. I'm so excited. Thank you for the invitation.
Okay, pleasure. I'm going to let you talk a little bit about yourself in a minute. I just want to position today. There's been this webinar has been in the making for quite a long time. Just to share our personal stuff, as Kirsty went through a family situation with her mom being mentally incapacitated 3 or 4 years ago, and that was really tough on the family. And we sort of at that point already said, listen, we've got to do something, because we realize it's difficult for the average person to cope with. But we didn't. Then my family, unfortunately, is going through the same thing with my dad. Again, we sort of said we need to do something about this, and we didn't. And then interestingly, Vessel, in his FPI refreshers, he shared publicly the situation with his mom and what they're going through, and just the struggles with the day-to-day practical stuff, and that sort of was the clincher. And I said, no, we've got to find somebody that has dealt with the appointment of an administrator. And I looked everywhere and I couldn't find a single advisor, not one. And we work with quite a few, and I couldn't find somebody that knows how to appoint an administrator or who's got some practical experience about it. And then finally I got hold of Chamonie, and so excellent. So thank you very much, Chamonie. That is fantastic. So finally we've got an expert, somebody that does this day to day. So we're really pleased to have you on. So Chamonie, maybe just if you can just start by maybe introducing yourself, and how did you get into this personal trust administration? And I saw on your LinkedIn page you refer to it's important to have a calling. So maybe if you can share a little bit about yourself with us first.
Thank you, Benny. Yes, so I am a director at TMJ Attorneys. It's the firm's name is actually Tomlinson Gooney James Attorneys. You need to be sober to pronounce that. That's the sobriety test. Our head office is in Pietermaritzburg. We have a big office in Umhlanga. I head up the office in Sandton, Johannesburg, and then we have a big presence in Cape Town, and the Cape Town clients are also my baby. So we have a trust division, Lighthouse Trustees Pty Limited. It's a separate company, and we perform our trust administration services through Lighthouse. Even though it's dealt with, we only have one employee in Lighthouse, a marketing manager, a systems manager, but then TMJ actually supports Lighthouse. So there's always an attorney, a trust expert, a deceased estates expert, a curatorship expert that deals with these type of matters. I started out at the Soweto Legal Aid Board, and I did my articles at the Soweto Legal Aid Board way back when. I'm not going to give my age away, but I was admitted as an attorney 20 years ago. And about 15 years ago, I actually decided to leave practice for a while and join a trust company as a senior legal advisor. I was under the impression that I'm going to do contracts and commercial agreements, which I loved. And they actually threw me into the deep end and said, well, we set up trust. We have a presence in the Isle of Man. We have offices in Mauritius, and we want you to deal with the trust administration for our South African clients and setting up companies and trust structures for them. So it wasn't really a choice, but it became my passion, knowing and also realizing that there's not a lot of expertise in that area. As part of my practice, which I call a fiduciary practice, it entails obviously trust administration, some company administration, deceased estates, wills for clients, estate planning for clients. And then about 4 years ago, I was approached by the first client who said, do a curatorship application for me. I did some research and then came across Section 60 of the Mental Health Care Act, in terms of which you can bring the application through the master's office. From a cost point of view, it just made sense to me to try that, and with great success. Luckily, it was the Johannesburg master's office. And now I assist more and more clients with exactly that same problem. Is you have a family member who's been diagnosed with dementia, early stages of dementia or Alzheimer's, or a stroke. And we do administrative applications, and I am, one of the only people I know who bring these applications. Obviously, there are other attorneys and organizations who does that. But yes, I've become quite an expert in applying for administrators and curators.
Awesome. What gets you up in the morning?
My work. It gets me up. I'm passionate about it. I love sharing information. I do a lot of training. I give a lot of training on various topics to people. I just believe that it's, as an attorney, we need to, and as anyone who has knowledge on certain topics, you have to be prepared to share that with others and not keep it for yourself. So helping people, assisting people, seeing instructions through and seeing what a difference it makes in people's lives, that gets me up in the morning, definitely.
And that's awesome to hear. I mean, like, obviously I know most, if not every single person on this webinar, and I must say that is consistently across the board in our industry, is that people have that attitude, that they want to help others, they want to help their peers, they want to further their knowledge. So really, really appreciate that, Chamonie. All right, so let's kick off here. So the one thing about AssetMap, we talk about advice engagement, in other words, engaging clients, but really importantly, if we want to engage somebody on a topic, it starts with what we call clarity. There's no clarity if we as the advisors aren't clear, if the clients aren't clear, if there's no clarity, we're going to struggle to build understanding. And if there's no understanding, we can't start engaging. And so the purpose of today really is to build that clarity for ourselves and our understanding. We're not going to get into the client engagement side today. So the softer aspects, how do we engage clients? That transition management, which is a whole different topic in itself, because it's emotional and it's hard for people, but we're not going to go into that engagement side. If that's of interest, maybe put that into the comments, and maybe we'll get Kirsty. I mean, she's really good at that, and maybe somebody like Louis, or like an expert on transition management. We can talk about that softer side. But so today we're going to focus on the more technical side. And so Chamonie, to kick us off, I think most of the audience, thank you, Louis. Most of the audience are familiar with the traditional tool. So I want to jump straight into the appointment of an administrator. So if you can maybe take us through that process, just unpack that for us. What is the process to appoint an administrator in terms of the Mental Health Act?
Okay, so Section 60 of the Mental Health Care Act specifically provides that anyone above the age of 18 years may bring an application to the master's office on behalf of a person or in respect of a person who is mentally ill or who has a severe and profound intellectual disability. So that already distinguishes it from the traditional curator applications to the High Court, because through the High Court, it can be brought in terms of a person with a number of issues. The person could be a squanderer. So that's where the administrator application is distinguished. It must be for a mentally ill person or a person with a severe and profound intellectual disability. Under dementia, or the use of resort under dementia, Alzheimer's, I have a client who had a massive stroke. So we brought an administrator application because obviously in his specific circumstances, there was the impact of the stroke was that he is mentally incapacitated. So that's the first thing. I think the confusion lies where the Master's Office in the Act prescribes that it can be brought, and then there are references to assets to the amount of 200,000 Rand and annual income of 24,000 Rand.
If I can just interrupt there, that is the biggest misperception in the industry that I've come across. So please, if you can clarify for us, because there's this understanding that if a client's got assets more than 200,000, they can't make the application.
Yeah, so that's a myth. It's simply untrue. The only reason why the master sets those limitations is for the master to evaluate whether an investigator must be appointed to investigate the application, and below 200,000 Rand worth of assets, and if the patient earns less than 24,000 Rand per annum, then the master will not appoint an investigator and will simply proceed with the issuing of the letters of appointment. If, however, the value of the assets exceed 200,000 Rand, the annual income is more than 24,000 Rand, then the master has to, in terms of the Act, appoint an independent investigator to investigate the application. And the purpose of this investigator is the same purpose of the curator ad litem in the High Court application. So you bring the application, the High Court application, ex parte. So there's no respondent in that application, and the same goes with the master's application. It's a form that you complete. I'm a pliggie, so I add an affidavit, additional affidavit by the applicant from the point of view that I don't want queries from the master. I want to avoid any queries from the master, and I want to give them as much information as possible. So the purpose of the investigator is an independent person to investigate whether this application is actually valid, whether it's not a family member who wants to sideline the patient and get access to that person's financial affairs to squander it or to use it for him or herself. And it's the same purpose as the curator ad litem. I have to just add there that in the Johannesburg and Pretoria Master's offices, the master themselves or the master's office appoint that investigator. So it's someone that we do not select. And that's what I like, because you have that independence. It's not something or someone that we can bribe or we can influence and say, just give us the investigator. Here's the investigator report, just put that in. But in Cape Town and in Durban, very interestingly, is when we bring applications there, they ask us to nominate the investigator, which I believe defeats the purpose of the investigator, because now you can use a colleague and say, or a friend and say, do the investigation. So the first step will be to bring that application. The master will then evaluate that and make a determination.
Yes. Just to be clear, so is the person that brings the application, is that the person that will be appointed as the administrator?
Yes.
And
so
who can, like a family member, or who can,
yes,
can be anybody
anyone
that the client wants or the family wants to appoint?
Yes, in all of the applications that I've done thus far, it's a family member. It's a daughter or a son, a spouse of the patient. Now, the master may ask security under certain circumstances, and I preempt that question already in my application and in the affidavit. So I want to avoid a situation where the sole heir, who's also the daughter of the patient, needs to provide security, because that's absurd. There's absolutely no reason for that. So I would say, here's a copy of the will. The siblings or the kids are the sole heirs, and they also nominate their sister or the brother to be appointed as the applicant or the administrator to the patient. So it can be anyone. In the High Court, it's a little bit different, because there you have a curator ad litem who does the investigation, who's usually an advocate, and then a curator bonus as the end result will then be appointed. And the High Court prefers that person is a liquidator, someone who acts as curator on other applications, etc., as part of their practice. As a firm, we don't take on the curatorship appointment. We have made a determination in that sense that we won't take up that appointment. So on all of the applications that I bring, that applicant will be the client who came to me and approached me and said, we want to do it for my mother or my father, or whatever the case may be.
And again,
yes.
sorry to interrupt, Chamonie.
No, please
I don't want to
interrupt.
break your stride, but there's a question here from Shannon just asking if there's no family member available, or either that because they don't want to, or they themselves aren't in a position to do that. I'd imagine you'd want, then you probably have to choose carefully. And her question is, could it be somebody like a financial advisor? I mean, my quick take is, I mean, that's probably a lot of responsibility to take on, and you need to make sure that you can deal with the administration of it. But yeah, just if it's not a family member, what are the options?
You can, yeah, I mean, the companies and the attorney firms who does liquidations, they're usually willing to take up the curatorship appointment. They know exactly what to do, the advertisements, the requirements from the masters, directors from the masters. And you need to annually comply and prepare a report for the master in a prescribed format, as you do with a deceased estate, the liquidation distribution account, report to the master. So it needs to be someone who is conversant with the topic, who knows exactly how to do it. With the applicants that we have, family members, they're laymen. So we guide them through that process, and we also send them in the right direction as far as accountants are concerned, accountants that we know work with curatorships and administrative applications, so that and who know the prescribed format. For a financial advisor, I would look at the potential conflict of interest, because if you are the financial advisor and you're investing on behalf of the patient, does that not bring a potential conflict of interest for you when you're appointed as the curator? That would be my question, but there's no limitation on who it may be. There's no exceptions as to who it may be or may not be. It can be anyone who has an interest or nominated by the family members to be appointed as the administrator.
All right. Okay. So then just to recap, so any person can bring the application, and if it's the estate is above 200,000, there needs to be a investigator appointed, and either the master will do that, or the applicant would need to appoint that investigator, and that'll be some professional person, like a lawyer.
It's usually an attorney.
Cool.
In all of the cases that I did as an attorney.
And then is there some sort of medical, like, in other words, what's in the application? Like or maybe what's that format of that application, and what's included in it?
Okay. So there's a prescribed form, the CB47, which I am absolutely willing, CB1147, which I'm absolutely willing to share with you. It's in any event available on the master's website under forms. That's a prescribed application. And with that, you need to provide at least 2 medical reports. Those medical reports need to be at least one specialist, so a psychiatrist, neurologist, depending on what the patient's incapacity is, and then a GP. They've accepted a GP, a general practitioner who knows the patient, who's worked with the patient, who's aware. Very importantly with the medical reports is that it needs to be less than 6 months old. So I just by default ask the patient or ask the applicants, the clients, to go back and get new reports so that we know that it's recent, and it needs to be stamped by that medical practitioner. And in that report, the medical practitioner must confirm that the person is no longer able or capable of managing his or her own affairs. In some of them, they go a bit further and say they support the application as for a curator or administrator for the patient, but that's not an ultimate requirement from the master's office. It's just a nice to have. I love it when they do that. I ask them sometimes to do it if they're willing to, but more often than not, especially the specialist, the neurologist, will just give a report and say, this is the diagnosis. There's no prospect of recovery. It's a degenerative disease, especially with dementia and Alzheimer's, and the 2 medical reports must then accompany this application. The additional information that you need to provide to the master is the value of the assets. So as you do with deceased estates, where you have the preliminary inventory, the J243, you will also give the master indication of what the assets are of the patient, but then also the liabilities. And annual income, very important information on that. And lastly, a list of family members, friends, colleagues, relatives who are able to confirm the status of the patient. So these must be third parties. They may be related, but that the investigator can call and say, are you aware of this? Do you know this person? Do you know that he or she has been diagnosed with dementia, Alzheimer's? How long ago have you seen them? Can you see it with your own eyes? Is there any layman witnessing of the person's condition? And it just assists the investigator. So that's basically the application. As I said, I go a step further and I draft an affidavit on behalf of the applicant, as you would do in a curator application in the High Court, to confirm and provide additional information to the master and to the investigator, just to speed up the process, so that there are no back and forth from the master's office or from the investigator's point of view.
And then typically, if you and I mean, that sounds relatively straightforward. I mean, that's not that complicated. If it then goes to, okay, so you're saying we have to submit it to the master's office, and my understanding is the master's office in the jurisdiction where the client is. So the master's office, what's it, Cape Town, Pretoria, Joburg, Bloemfontein, Pietermaritzburg.
Yeah, I mean, it's everywhere. Thohoyandou, the master's offices are everywhere. So wherever the patient resides, that is the jurisdiction where you will bring the application. There are a couple of exceptions on that. So if the applicant and all the family members, the person who's actually going to administer, if it's more convenient to have that in Johannesburg, but the patient is in Durban or in Pretoria, then you can ask for the master in Johannesburg then to deal with it from a practical point of view. But they hardly ever agree to that. So we try and make it work where the patient resides. And the practicality, in practical terms, you would usually reside and have the patient as close as possible to your closest family members to visit them. And that's also something important that you need to say in the application is that I visit the patient often. I have contact with that patient. I care for the patient's welfare. It's important to the master to know that, and that's part of the form that you complete to say, how often do you see that patient?
Yeah, in fact, there's, I mean, it might be a simple process, but there are a lot of nuances. And I think you could easily trip up if you miss some of those nuances. Then I can imagine it's quite an administratively complex process. Maybe, and then just what is the time? Well, first of all, is there a cost with the application?
Yes, so if you do it on your own, if a client decides, you know what, we're going to take a stab at it and do it on our own and complete the form and submit whatever the master requires, there's no cost involved, absolutely no cost. For the application itself. If a client approaches me, then I charge by the hour, and it will depend on how much the client is prepared to do. So on one application, for instance, the applicant actually did his own affidavit. I didn't have to draft that. So it's really just time spent. And from a fee point of view, I've never charged more than 30,000 Rand for the application, and the least I charged was 10,000 Rand. So you can, on average, it's 20. It really is about 20,000 Rand. That's the time spent, but it also depends on how much time I actually have to sit and spend on the application itself, liaising with the master's office, etc. But we have a lodging agent, which is a flat rate. He charges once for submitting the application and retrieving the letters of appointment. If there are queries in between, I'll convey that to the applicant and say, okay, our lodging agent has now gone 4 times and there are queries in between that he needs to deal with. Can we increase his fee to say 1,000 Rand or whatever, because he charges a flat rate of 500 Rand. So it really depends on the time I actually have to spend as far as the fees are concerned.
Okay. And then just in terms of timelines, and I know it's like how long is a piece of string, but let's assume it's a well-prepared application. Just give us a sense of what that timeline is.
Okay, I can give you facts on how long it takes. So in Johannesburg, I lodged an application in April of a specific year, and the interim letters of appointment was issued in May. So that's the very next month. And then the final administrative application was issued in August. So that period from the issuing of the interim letters of appointment, where the investigator then is appointed and do the investigation, there may be certain queries from the master, and then the master issues the final letters of appointment. The handy thing about an interim letters of appointment is that it gives you the same powers as it does in the final appointment. So you can already deal with assets, investments, the investment obviously subject to the approval of the master in the meantime. So that's Johannesburg. In Johannesburg office. Pretoria office, February issued. May, the final letters of appointment, they didn't even issue an interim letters of appointment. So that the whole process from start to finish was 3 months. February, March, April, May, yes. Then in Durban, September, I lodged an application. The interim appointment was issued in January, so you can see that it takes a little bit longer in the Durban office, but I had to select and find an attorney in Durban to deal with the investigation, and that took quite some time because they are few and far between who deal with these applications. And then the interim appointment was issued in January, and the final appointment was issued in August. So that took a little bit longer. And then I have my stepchild in Cape Town at the moment, where my first application in Cape Town went absolutely splendidly. I issued it in September. The final letters of appointment was issued in March, so let's say 5 months. But at the moment, I'm sitting with an application which I lodged September last year, and we still haven't received the letters of appointment. And that's really the main reason for that is that I have now worked with 3 different examiners on this exact same application. And every single time they have new queries, new questions, say that they haven't received it. They asked for a bond of security, which is absurd because it's the daughter, sole heir of the patient. There's no reason why security has to be provided. So it really depends on the master's office. We're all aware of the challenges experienced with the master's offices at the moment. But yeah, my stepchild has taken the longest thus far. And I mean, if we deal with a curatorship application a bit later, if you want to know how long that process takes, then I also have the stats on that. It will take a minute. I have a perfect example of it.
We will, yeah, we're going to come to the differences, you know, in terms of cost and time and stuff. We'll get to that. All right. So if I can recap, I mean, there's a fairly straightforward application process. There's a lot of nuances around making sure it covers or it prevents going back and forth. And yeah, but I mean, that's, and of course, it's dependent a little bit on the bureaucracy inside the master's office. Once that letter of appointment is received, what is the ongoing, you know, the administrator, what are the ongoing administrative duties? I mean, they obviously need to sort out the affairs of the client or the patient, but in terms of the master's office, what are the requirements?
So the master is actually quite cool in that sense, is that they issue very clear directives with the letters of appointment. The first thing that needs to be done, and that only needs to be done once, is it needs to be advertised. So as you would advertise an estate late in terms of Section 29 to the creditors, you will also do an advertisement to inform the public of your appointment as curator or administrator, and any creditors can then lodge a claim, you know, and would know where to lodge that claim so that everyone is aware. That's a once-off. Then a new bank account must be opened, as you do with an estate late. We have, however, achieved the keeping of the patient's bank account because of pension funds being paid, an annual or monthly pension fund being received in the patient's bank account, especially SASSA, extremely difficult and impractical to get that to change. And we've received the master's approval to actually retain the patient's bank account. And then the administrator will just get access as a signatory to that bank account. And then from the date of the appointment of the letters by the master, within a period of 1 year, 12 months, you have to report from a financial point of view and submit financial reports to the master in a prescribed format, very much similar to the liquidation distribution account in a deceased estate, and report to the master as to what you have done during this year. So if you need to make monthly payments on behalf of the patient, so for his or her care, personal things, you know, toiletries, things like that, you have to, after the letters of appointment has been issued, you have to go back to the master and stipulate those monthly expenses and get one approval from the master to continue with that. If you want to deal with the assets of the patient, I usually foresee and ask the clients to foresee what you want to do. So do you want to disinvest? Do you want to move an investment? Do you want to reinvest, or what do you want to do? So that we get the master's approval in one single go, because it's just more practical. But if you, for instance, want to sell a immovable property, the master's approval is then required to sell immovable property or shares in a company, etc. So that might delay certain things, especially when you want to sell immovable property. But the same process is followed in deceased estates as well. You still need the master's endorsement in terms of Section 42, so of the Administration of Estates Act. So that that's the ongoing. And from there, when you have all the approvals and you've dealt with it, I guess within the first year, you would know exactly what you want to do as the administrator, and you've achieved that. Then it will just run, and each year you will submit financial reports to the master.
Awesome. Okay, so I think I'm going to, if there are more from the audience, if you've got more technical questions on the appointment administrator, yeah, then please post them in the comments. We'll either get to it in the session or afterwards. But now I want to change, Chamonie. I want to compare the appointment of an administrator versus the options of curator bonus or a special trust. So I'm going to, and we're going to use asset back and see. And in fact, yeah, Shannon asked a great question there. What can we do beforehand? So hopefully in our example, we're going to be able to cover that, Shannon.
Yeah, I'm excited about this conversation because we can all avoid having to go through this whole process if the financial planners are proactive, beforehand.
Okay, awesome. Here's a big challenge from Chamonie. So let's find out, what do we need to do to be proactive. So here's a relatively simple, straightforward family. I'm just going to introduce you quickly. John and Joan, they retired. John is 70 years old. Joan is 65. Just quickly, some things, they've got a joint will, got medical aid. On the income side, they've got a rental property in John's name, so there's some rental income. He earns a monthly pension plus a discretionary annuity. There's the living annuity. He's got some money in a bank account, some fixed deposits, and there's the property. And then in Joan's name, she's sitting with a bank account and some discretionary investments. They've got one daughter, Janet, that's married, and she's 35, and she's living in the USA. So it's, let's call it an average retired couple. Now, and I mean, maybe we're going to get to some of these, because probably Chamonie is jumping up and down already saying, listen, there's some red flags here, but let's not. We're going to get into the red flags in a moment. But I think that on that question around being proactive, I think whatever solutions we consider, it also depends on the situation or the circumstances of the client. So one, and I'll say it, it's one of the things is what is the condition of the client? What is their medical condition? How far is let's say dementia, how far is it advanced? And then, of course, what's the life expectancy? And I've done some research, and it varies quite widely. The life expectancy can be as little as 2 years to as much as 26 years. So certainly that is an aspect to consider. Maybe anything else, Chamonie, on when you look at a family or somebody that approaches you and you need to decide which options to choose. What are some of the things that you consider?
Well, as far as the administrator application is concerned, firstly, is there a power of attorney in place? So perhaps we should deal with that. So under certain circumstances, you would provide a power of attorney to someone to act as your agent. The problem with the power of attorney in South Africa is that it's not an enduring power of attorney. In European countries, it's an enduring power of attorney, and I know that the legal the Law Reform Commission is looking at that, but has been looking at it for the past 5 years to change that to an enduring power of attorney, because that will solve all of our problems. But the power of attorney lapses automatically when a client is deceased, obviously, patient is deceased, but also when that patient is mentally incapacitated. The principle behind that is you cannot provide or give a power of attorney if you're not able mentally to revoke that power of attorney. So it automatically lapses. And unfortunately, I've come across so many clients and financial advisors who advise their clients to just continue to act in terms of that power of attorney after they all know. And this is illegal. You know, it's illegal to act in terms of an invalid, to act in terms of a power of attorney after the patient is mentally incapacitated. The reality is that dementia and Alzheimer's are degenerative diseases. So you might be diagnosed 4 years ago, and you would still be lucid. You will still be able to sign a will. You will still be able to deal with your own affairs. And that's actually where the financial advisor comes in. And I'm sometimes so jealous of your relationship with your client because it's very personal. Financial and investment advisors are the closest, in my mind, people, third-party people involved in clients' lives, because you deal with their finances. That's very personal. So in all probability, if you have a good relationship, which you should have with your clients, they would come to you first and say, John or Joan has been diagnosed with dementia, early stages of dementia. How do we deal with it from here on?
And then maybe what are some of the proactive stuff? And because you mentioned it's degenerative, so the client may well be lucid in the beginning stages. What are some of those proactive steps that we can take?
Well, I think a trust comes in very handy in this scenario, because what you can do is you can ring fence the patient's assets in a trust. The added benefit of that is that you can register it as a special trust in terms of the Income Tax Act, which means that the trust will not be taxed at 45%, but will be taxed at the individual, so the patient, the beneficiary's personal rate, personal income tax rate, which is a great saving and a great tool. The challenge is there are only two ways to get assets in the trust. It's by way of a loan or by way of a donation. By way of a donation doesn't really make sense if you take into consideration that you only have 100,000 Rand tax-free donation for an individual to make every year, and everything above that will then be taxed at 20%. So it doesn't really make sense. My advice is then to set up a trust for the family, with the beneficiary being the patient. Let's make it John. Sorry, John, you're going to be the person who has dementia. And so John would be the sole beneficiary in terms of the Income Tax Act. He must be the sole beneficiary. You can't benefit other family members. Otherwise, it won't qualify as a special trust in terms of the Income Tax Act, and you won't get that tax benefit. So you can transfer some or all of John's assets into the trust by way of a loan. And then you sit with that loan, and yes, Section 7C that I assume you're all familiar with by now will apply to that loan, but you will still have that saving, because remember that that income tax portion or that interest earned on the loan is taxed in John's personal hands, which, you know, he's going to receive little income or no income. So that would still be a benefit. And then in John's will, while he's still lucid, you then update his will to bequeath those loans to the trust. So at the end, you get to a scenario where you have ring-fenced the assets. You don't need an administrator to deal with the affairs. You can immediately make payments of his care, his maintenance, all of the things that you were concerned about by ring-fencing it in a trust, and then for the trustees to be appointed to do that on his or her behalf.
In fact, I'm just going to jump to, because I've done a map for that. I just want to jump to that example quickly, okay. So this is, but what I just assumed, the real amateur is we're going to move everything on John's side into the trust. But I think what I'm hearing, what you're saying, Chamonie, in this example, you made things like, for example, that rental property, because that surely there's going to be administration. So it might be that you move the rental property and his share of the retirement home or something. But it might be that, you know, that we leave a bank account or something here, because that can be administered in terms of another I know, look, so in fact, that's a really, I never thought of it like that. So in other words, you could split up the assets and move some into a special trust, and the balance could then be
Yes.
through an administrator.
Yeah, absolutely. I mean, you sit and assess with the clients what are the potential hurdles that you're going to face with John not being mentally capable. The rental flat, if that's in his own name, will pose a problem because he won't be able to sign lease agreements. So, and a power of attorney will not work because he's already mentally incapacitated. So that's one of the assets that I will definitely move into the trust, so that the trustees are authorized to sign lease agreements and deal with the leases, receive the rental income, and then also receive it in the trust and then pay it over to John.
Yeah, and I mean,
taking consideration, I'm sorry, Benny, for interrupting, but also take into consideration that donations between spouses are tax-free. So that's also something to consider, as to, while he's still lucid, let him donate all of his assets to his wife. Go through the pain of and the cost of transferring the property, the rental flat, for instance, to his wife, hoping then that something similar doesn't happen to her. But then you don't have any donations tax payable. So, and while we still have that tool, I don't know how long we will have that tool available to us, but that's also an option. And you then avoid the trust situation completely.
Yeah, and I'd imagine if a client already has exposure or over the years they've got a family trust or some experience with dealing with trusts, I mean, this certainly feels like an appealing option. If the client's never been exposed to a trust, one maybe need to think about it twice. But yeah, I mean, this does feel like a good option if clients are already familiar with trust in their financial planning.
Yeah, absolutely. I sit with an actual client, absolutely brilliant mind, and he was diagnosed 6 months ago with motor neuron disease, very aggressive. And immediately he has a family trust, and the bulk of his investments are already in that family trust. It has been seamless. We removed him as a trustee in anticipation of him no longer being able to sign a resignation letter. So we've already removed him as a trustee. He's at least very willing and cooperative. You know, you might find situations where the client doesn't want to lose control. He's maybe in denial with his diagnosis and still thinks that he wants to be in control. But with this specific client, it's been absolutely seamless because he already has a family trust. We have, with all the medical bills, with everything that we needed to cover that the medical aid didn't cover, we could just simply pay it from the family trust. Now, the difference here is that this family trust, he's not the only beneficiary. His wife and his children are also beneficiaries of this trust. So we won't be able to register that as a special trust. But from a continuity point of view, it's been a wonderful tool to use in this specific scenario.
Yeah. Well, let's now jump to then I just want to jump to quickly the example. Let's just see if I've got it here. Yeah. So in other words, now I want to just, because you've really nicely explained the use of trust, if we could just for a moment compare the other option, and that's going to the High Court to appoint a curator bonus instead of an administrator. It'll probably end up looking something like this, where all the assets and liabilities remain in the client's name, but there's a curator or administrator appointed to help the client make decisions around those assets. Maybe just briefly explain to us the key differences between a curator and an administrator.
Okay, so I mean, the function remains exactly the same. The end result remains exactly the same. The person takes hold and management over the patient's asset. So the end result remains the same. It's just the process that differs. So my learned colleague and I, Advocate Nicole Lombard, we had a very animated and sometimes heated discussion on Sunday, because I told her that I was going to present this webinar, and she actually recently did a curator bonus application. And of course, she's an advocate, so she would always prefer going through the court, through the High Court. Now it depends on what the actual circumstances are. So with dementia and Alzheimer's, this is a degenerative disease, so you can still plan. With a stroke, for instance, that's immediate. So you're going to have to, you don't have any other options available. You can't set up a trust now. You can't let him sign a new will. You don't have those options available. How urgent is this is the first question. If it's urgent and you bring it on an urgent basis in the High Court, of the fact that the High Court is extremely strict on urgency. So urgency will always be the first argument when you bring this application. It's an ex parte application, so there's no respondent. You bring the ex parte application in respect of the patient, and the first application would then be to appoint a curator ad litem. That's the investigator, usually an advocate who does all of the investigations and report back to the court to say, I'm quite happy that the facts contained in this application is true or are true, and I'm happy for this applicant or a curator bonus to be appointed for this person. Now, Nicole says to me that you can get an ex parte date within a month at the High Court, and that's true. So I have an actual example where I'm assisting clients now to replace a curator. And what happened here was last year in July, on the 27th of July, this affidavit was signed. I'm not sure when it was served on or filed at the High Court. On the 25th of August, less than a month later, the court issued the order for the appointment of the curator bonus. So you can imagine the curator ad litem was already appointed, and now with the final stages. So for all practical purposes, you've achieved what you wanted to achieve within a month. This is not on an urgent basis. This is on a normal ex parte basis. On an urgent basis, you can get a court appointment, a court order within 3 days or 5 days. So if you can prove the urgency. So I'm talking about the normal application that we all face with regards to the master's office versus the court or the High Court application. But then there's a curveball that comes in, because when the court grants the order, this is not the letters of curatorship that's been issued. That letters must still be issued by the master's office. So the applicant will then take the court order, and in the court order, the court will instruct the master to issue the letters of curatorship, and you will then lodge all of the documents to the master. In this specific scenario, last year on the 25th of August, the court ordered that a curator be appointed. The master issued the letters of executorship last week on the 5th of July, 11 months later. So in my mind, when I stated the actual facts and the time frames from an administrative point of view, and that application that you bring through the master, so it's already with the master at least, and the master is dealing with that from the start. It is on average between 4 and 6 months from start to finish. And now you sit with a situation where, yes, within a month you can get a court order, but the master must still issue that letters of curatorship. And in this specific example, it was only issued almost a year later.
Mm. I mean, that's
and
really,
then the cost.
Yeah, I was going to say that the cost would be a little bit more because the advocates and,
Yes.
and the High Court, in fact, would probably be a lot more. Maybe just is there a ballpark number or not? Because I don't want to say it's a lot of money and then it's like a 20,000, that's 25 or something. But my understanding will probably be materially higher.
Yes, it will. So I charge between 10 and 30 depending on how much work I need to do. But now you have to appoint an advocate to appear on behalf of the client. So there's a cost involved. You can use a baby junior, which is much cheaper. They charge 850 Rand an hour. You know, my hourly rate is much higher than that. So you can use a baby junior counsel to move that application for you, but then you need to appoint a curator ad litem, another advocate who's going to charge for his or her time. And then the back and forth of filing the application. So you have to have an attorney. So it's an attorney first who will brief the advocate, who will advise the court on who the curator ad litem they would want to choose or provide the court with 3 options. So Nicole says to me that she charges between 40,000 and 80,000, depending on whether it's on an urgent basis, because then immediately there's a massive increase in the fees because it's during the night you need to draft papers and bring it on an urgent basis. but she says between 50 and 80, 50 and sometimes 100,000 rand. So it's definitely more expensive than just the normal route, not the normal route, the abnormal route that nobody knows of, through the master's office.
All right. Listen, actually, I do want to go into more detail, but on that, but I think we're going to run out of time. So let's rather just deal with one or two questions, and then then we're going to wrap it up. So we've got a question here, Chamonie, very technical. It says, would severe autism be classified under the Mental Health Act? As in other words, could you make an application for somebody that has severe autism?
Yeah, so I mean, I know that autism is not necessarily an intellectual disability. It's perhaps a challenge, but it depends on how severe it is. So, and that will obviously depend on the neurologist to say that, is this person capable of managing his or her own affairs? And that's where the question lies. So it depends on the severity and whether the person can actually deal with a bank account, deal with money, buy groceries, do things like that. It's from a practical point of view. And the neurologist will make that ultimate determination. An expert needs to make that ultimate determination to convince the master or then the High Court that this person has a severe, profound intellectual disability, because autism isn't always a disability.
So that I guess is a factual thing, and maybe it'll depend on the medical reports. But so you're saying it could be, but depends on the severity.
Absolutely.
Maybe, and I mean, I mean, these questions are so interesting. We're not going to have time to answer them now, but I mean, one of those will be challenged in those sort of early stages of dementia. But again, I think my very rough understanding of the law is that a person could have a lucid moment, and it'll be up to the people that challenge it say that was not the case. So I mean, there's been a lot of legal cases around that. So
absolutely, I've also been personally in cases like that. So and the court determined that the client was lucid, but we also made exceptional measures to make sure that we would be able to prove that. So a neurologist literally examined the client the day before you sign the will, and also found that he's capable of signing a will. And that was very, very, very early in the stages of dementia.
Actually, but that is a super important point. I'm glad you made that, Chamonie. So what we're saying is, if you want to change the will in those early stages, make sure that you can prove or that it's very likely the person was lucid. So don't get caught out by just assuming it's early stages. Nobody's going to challenge that. So especially if it's a complex family situation. And then maybe just last thing quickly, Silma is asking us here. So if we can sort of summarize, if we see those sort of early stages of mental incapacity, what should we as advisors be doing? I think we've covered all the detail. I'm just trying to think to summarize it. I think it's, and you must say as well, Chamonie, but for me, it's, we've got to be able to provide clarity to clients. Yes. It's only because through that clarity, it'll come understanding, and then we can engage with them on the specific options that may work better for them. So, so
options, keep the client options, be informed. And make sure that you're informed. And if you're not, refer the client to someone who is informed, because they will appreciate that more than you wanting to advise them on topics that you're not really conversant with. But provide the client with options so that they can make informed decisions, get tax advice on transferring of assets between spouses, get, there are so many experts in this area. Make sure that you're making the right decisions for the client that will work for the client.
Yeah, and I like that as well, Chamonie. I think we're going to end off on that note, is to say that, listen, these are important conversations, and they're hard for clients. I mean, from personal experience, that is difficult for the family, and often they don't know who to turn to. And so I think as advisors, you know, like we're in a really special, like as you mentioned, important position to open up those conversations. And I think the real trick, and I mean, if you want to know why people use Asset Map, that is, it's an easy way to open up difficult conversations like that.
Absolutely.
So whether you use Asset Map or something else, I think you've got to find ways to open up those conversations in a way that doesn't confuse clients.
Yes.
All right, so we're going to have to end it off there. Chamonie, any last words from your side?
No, again, thank you. And I mean, I'm happy to do a follow-up webinar on this if there's a need. I'm also happy to engage with anyone who has questions. Please publish my contact details, my email address, not my mobile number, but my landline. I'm very much approachable and accessible via email, but I'm happy to answer any questions. If any of the attendees of this webinar sit with situations like this, please let me know. Please let me help you. Please let me give you advice on what you need to do. I'm happy to do that.
Yeah, awesome. Thank you very much. There's awesome comments coming through here, Chamonie. People are very appreciative. It's saying it's very insightful and very knowledgeable session. So it's absolutely, we're going to share your details afterwards with everyone. Yeah, and I think that the thing I take from it is the appointment of administrator is new. And yeah, I think it's worthwhile speaking to experts, you know, especially for the first few ones. You don't want to just go storming in there. Yeah, so absolutely. Yeah. So thank you very much, Chamonie. We're going to have to wrap it up.
No, thank you. Yes.
It was lovely talking to you, and thank you for the work that you're doing. Really appreciate it.
No, thank you. The same to you. The same to you. So yeah, all the best to everyone. Take care. And yeah, we'll hopefully do something like this again.
Awesome. Thank you, Chamonie.
Okay.
All the best.
Cheers.
Cheers. Bye-bye.
Okay.